wanna read you something. I think you're very nice. Hi, Samuel. What? I'm the only one. And now I just want to sing. I just want to sing. I'm going to be reading something today. I have nothing going on. What do you have going on, Samuel? Are you doing okay? So I thought I'd go live. So I need to like. Wow, that worked! Oh my god! Oh my god! Oh my god! Oh my god! Holy fuck! Nothing today. Nothing today. Well, Rooty Tooty Fresh and Fruity. Yeah, it's all gravy, baby. That's right, Samuel. That's one of my favorite sayings. I am, Rudy lost. And so, hi, Rogue. I am going to read a little bit. Now, it's a long document, so I may not get through all of it, but I want to just scan it together. And I thought, instead of like trying to record it, like I should probably just go live and do the thing. Do the thing. 57 pages! That's what it is! 57 pages! Here we go. I think that this is a. This is a. Hi. Hi, everybody. Okay, wait. I need to go over here. Okay. Hey, Muskie. I'm going to try and do this so that I can. Hold on. Home please. We are now processing. Just a minute. Thank you. Okay. Rudy Tooty, Fresh and Fruity, is lost. All right, settle in, kids. We're going to have a little reading time. Mommy's going to read to you today. I won't read in this voice. I'll read in a normal voice. But welcome, everyone. I hope you can hear me okay. I'm using a different microphone, so just let me know if there's any problems with the sound. Thank you very much. Okay, let's get it started. Let's get it started in here. United States District Court for the District of Columbia. Ruby Freeman et al. Plaintiffs v. Rudy Giuliani, asshole, and defendant. There you go. Judge Beryl Howe. Haven't heard from them in a while. Let's just see here. Okay, we're going to go through this. Memorandum opinion. The Federal Rules of Civil Procedure authorize liberal discovery for the sole purpose of assisting in the preparation and trial or the settlement of litigated disputes. Seattle Times Company, blah. With the only express limitations that the information sought is not privileged and is relevant to the subject matter of the pending action, but without differentiating between information that is private or intimate and that to which no privacy interests attach. As such, the rules often allow extensive intrusion into the affairs of both litigants and third parties. Crucial to fulfilling this central purpose of civil discovery is the parties comply fully and timely with their discovery obligations to supply relevant testimony and documents for a fair appraisal. Hi, Rumrose. Fair appraisal of the facts and a just determination. Obviously, only extant documents and data are producible, so parties must also take reasonable efforts to preserve potentially relevant evidence, including electronically stored information, also known as ESI, when litigation is reasonably foreseeable. And if you're Mr. Giuliani, guarantee it's reasonably foreseeable. To incentivize and enforce compliance with these procedural rules, sanctions may be imposed when ESI should have been preserved in the anticipation or conduct of litigation, but is lost because a party failed to take reasonable steps to preserve it. Your dog ate it is not good enough. Defendant Rudy is taken at his word that he understands these obligations. He is, after all, a lawyer. He assured the court directly that he understands the obligations because he had been doing this for 50 years. I can do it in my sleep, Your Honor. Transcript of the May 19th hearing, however, Giuliani has only given lip service to compliance with his discovery obligations in this court's orders by failing to take reasonable steps to preserve or produce his ESI. Instead, Giuliani has submitted declarations with concessions turned slippery on scrutiny and excuses designed to shroud the insufficiency of his discovery compliance. The bottom line is that Giuliani has refused to comply with his discovery obligations and thwarted plaintiffs Rudy Freeman and Wandrea Arche Moss's procedural rights to obtain any meaningful discovery in this case. Rather than simply play by the rules designed to promote a discovery process necessary to reach a fair decision on the merits of plaintiffs' claims, Giuliani has bemoaned plaintiffs' efforts to secure his compliance as punishment by process. Donning a cloak of victimization may play well on a public stage to certain audiences, but in a court of law, this performance has only served to subvert the normal process of discovery in a straightforward defamation case, with the concomitant necessity, did I say that right, of repeated court intervention. Slippery Rudy. Due to Giuliani's slippery discovery conduct, plaintiffs have filed 2 motions to compel production from Giuliani and his eponymous business, Giuliani Communications LLC and Giuliani Partners LLC. Compel the partners, resulting in 2 discovery hearings. I don't know. Is it minute or minute? I'm not really sure. Hi, Peace Love. Hi, Marie. Well, along the way, Giuliani has been afforded several extensions of time to comply with court orders and his discovery obligations. See the example. Blur, blur, blur. Blur, 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 blur. Oh, providing Giuliani with an additional 35 days to comply with the May 31st order. As the discussion below reveals, however, the result of these efforts to obtain discovery from Giuliani, aside from his initial production of 193 documents, is largely a single page of communications, blobs of indecipherable data, a sliver of the financial documents required to be produced, and a declaration and 2 stipulations from Giuliani, plus an old CVS receipt, who indicates in the latter stipulations his preference to concede plaintiffs' claims rather than produce discovery in this case. Wani! Oh, full moon, that's right. We got some, oh man, there's some fucked up moon energy going on. Can we just call a thing a thing? But I digress. Giuliani's preference may be due to the fact, about which he has made no secret, that he faces liability, both civil and criminal, in other investigations and lawsuits. I want to read this little footnote. In addition to Giuliani's recalcitrant discovery conduct, plaintiffs have also faced challenges in obtaining relevant information from his associates who were part of the effort by Giuliani and others to sow doubt in the fairness and legitimacy of the 2020 presidential election, further necessitating judicial intervention, blur, 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 via alternate means after plaintiffs sent considerable resources to serve Catherine Freese, authorizing plaintiffs to Catherine Freese. I can't remember who she is now. God damn it. I get her mixed up with the True the Vote person, but I know she's not the same one. Okay, anyway, I'll figure it out. After plaintiffs spent considerable resources to serve Freese 10 times over 4 months at 6 different addresses in 3 different states. That's fucking bullshit. Authorizing to serve Jenna Ellis with Rule 45 subpoena via alternate means after plaintiffs spent considerable resources to serve her 3 times at an address where she is believed to have recently resided and where her mother currently resides. Oh, great. Detailing Bernard Carrick's failure to comply with the Rule 45 subpoena and granting in part plaintiffs' motion to compel compliance. As to Carrick, plaintiffs recently advised that they contest Carrick's withholding of responsive records as privileged. Oh, yeah. Hand them over, fuckwad. And request in-camera review of 318 withheld documents, please. Status report, but given resolution of the instant motion by entry of default judgment on liability against Giuliani, plaintiff's request for in-camera review is denied as moot, since plaintiffs have provided no information to suggest that such documents would be relevant to the quantification of damages. As a result, plaintiffs have been denied access to discovery from Giuliani and his associates, both to support their claims and to defeat any defenses proffered at trial on the merits. Me. Okay, so March transcript. Giuliani stating that he has 7 or 8 cases that are pending requests for discovery, including not just civil, but criminal investigations. Do you see also this describing the submission in this case of declaration by Giuliani's defense attorneys in prior criminal investigation? Huh? Perhaps he has made the calculation that his overall litigation risks are minimized by not complying with the discovery obligations in this case. Whatever the reason, obligations are case specific, and withholding required discovery in this case has consequences, as you're about to find out. You can skip to the end if you want. Giuliani's willful discovery misconduct has now led inexorably to plaintiff's pending motion for sanctions due to his failure to preserve electronic evidence, seeking inter alia the entry of default judgment against Giuliani. See the plaintiffs. Oh, it's plaintiffs, not please. I don't really know anything. Against defendant Giuliani. Giuliani has also not complied. Hey, gal. Giuliani has also not complied with 2 other court orders requiring him both to produce certain requested routine financial documents relevant to plaintiffs' claims for punitive damages and to reimburse plaintiffs for attorney's fees and costs associated with their first motion to compel, failures for which plaintiffs request additional sanctions. Updated joint status report in August. Additionally, plaintiffs have sought sanctions due to noncompliance by Giuliani's eponymous business with document and deposition requests after their motion to compel compliance was granted as conceded. Facing court orders compelling his discovery compliance and potential default judgment as a sanction for failing to preserve ESI, Giuliani filed 2 personally executed but unsworn. He literally, it's Julie Rudiani. It's Julie Rudiani says. Giuliani sold his $6 million. Did he sell it? Holy fuck. Because he said he was putting it on the market. Anyway, okay. What are we doing? You're going to laugh at me with I don't know legalese, so I apologize to everyone who does know legalese and is laughing at me. As I said, PLS was a abbreviation for please, and it's not. It's plaintiffs. Okay. Facing court orders compelling his discovery compliance and potential default judgment as a sanction for failing to preserve. Oh, yeah, that's right. But unsworn stipulations. Oh, this was the stipulation. Okay, so he wrote this himself. Okay. For failing to preserve ESI, Giuliani admitting for the purposes of this litigation liability on the factual elements of plaintiffs' claims and their entitlement to punitive damages. See defendant's response, please, to the plaintiff's motion. Blah, blah. Superseding nolo contendere. I want that on a shirt. I'm a superseding nolo contendere. Boom. I'm going to Nolo contendere. That's my new name. Giuliani's stipulations hold more holes than Swiss cheese. Oh my God. Literally, this is written in a court order. I love this. Giuliani's stipulations hold more holes than Swiss cheese, and that's a lot of holes, folks. With his latest stipulation expressly reserving his arguments that the statements complained of are protected and non-actionable opinion for purposes of appeal. Giuliani superseding stipulation, which arguments were previously rejected in this court's decision denying defendant's motion to dismiss. See Freeman v. Giuliani. Blah, 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 blah. The reservations in Giuliani's stipulations make clear his goal to bypass the discovery process and a merits trial at which his defenses may be fully scrutinized and tested in our judicial system's time-honored adversarial process. I think they already owned it, didn't they, Marie? Muskie saying hi to everybody. The reservations in Julie at which is and to delay such a fair reckoning by taking his chances on appeal based on the abbreviated record he forced on plaintiffs. Yet, just as taking shortcuts to win an election, oh, ouch, ouch. Oh, that was that left a mark. Okay, Judge, that left a mark. Okay. Even potential criminal liability, bypassing the discovery process, carries serious sanctions no matter what reservations a non-compliant party may try to artificially preserve for appeal. Try artificially. Okay, well, that's better. The downside risk of turning the discovery process into what this court has previously described as a murky mess. That's a good one, too. Murky mess. May 19th, blah, 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 hearing trial, blah, blah, blah. That Rule 37 provides a remedy, sanctions, including entry of default judgment against Giuliani. Spoiler alert, that's what I'm about to do. Bend over. Given the willful shirking of his discovery obligations in anticipation of and during this litigation, Giuliani leaves a little other choice. For the reasons set out below. Hi, Spotman. Blur, 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 blur. Wait, what? Wait, where am I? Given the willful shirking of his discovery obligations in anticipation of blah, 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 blah. The motion is granted. Default judgment will be entered against Giuliani as a discovery sanction pursuant to rules this, that, and the other thing, holding him civilly liable on plaintiff's defamation, intentional infliction of emotional distress, civil conspiracy, and punitive damage claims. And Giuliani is directed to reimburse plaintiffs for attorney's fees and costs associated with their instant motion. It's the instant motion of the ocean. Marie, preserve the battery. In addition, as this case now heads to trial to determine any damages due on plaintiff's claims, Giuliani will be given a final opportunity to comply with discovery relevant to the determination of damages. I think they both own a condo in Manhattan. What do you think? Both compensatory and punitive, or face imposition of additional discovery-related sanctions under Rule Blibba in the form of adverse instructions and exclusion of evidence at trial as outlined in more detail below. Specifically, Giuliani is directed by September 20th to do the following. I mean, really, he has like fucked himself. Like he has ham-handed this entire thing. Like he's truly on his own. There is literally, I can't even think that a lawyer is actually advising him, right? Okay, anyway, he's got to do this by September. Produce complete responses to plaintiff's requests for financial documents set out in plaintiff's request for production numbers, blah, 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 and which he previously ordered to produce by June 30th. But he missed it. Ensure that Giuliani businesses produce complete responses to plaintiff's requests for financial documentation and viewership metrics, including RFP numbers 19 and 35, seeking records sufficient to show how his podcast called Common Sense generates revenue, including through advertising agreements and distribution contracts, and records sufficient to summarize viewer and listener metrics for Giuliani's statements on social media and Common Sense from the date of original publication through the present, including reach, count, page visits, post shares, time spent, impressions, and listener numbers, like, share, and subscribe, and the number of online views and impressions of any statements Giuliani made about the plaintiffs as described in the amended complaint, blah, 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 as well as designate one or more corporate representative to sit for depositions on those businesses' behalf. I hope it's Ted. Hi, Summer. How are you? Oh, Summer. I love it when they make it easy. Isn't it great when people make it easy, Summer? Anyway, we'll talk later. Reimburse the original attorney's fees associated with their successful first motion to compel discovery in the amount totaling $89,000 with interest. Hello, from July 25th. Yeah. And then ensure that Giuliani businesses reimburse plaintiffs' attorneys' fees associated with their successful motion to compel discovery from the businesses in the amount totaling $43,684 with interest on that amount to accrue from September 20th until the date of the final judgment. If his businesses fail to comply. I love you too. Yeah, no worries. Oh my God. Yeah. Just stop moving trucks. Jesus Christ. What the hell? And wait, let me just say one thing. When I start filming the place I work at and live streaming from there, we've got a problem. Okay. Anyway, but I digress. Okay. Background. Here we go. This is the good part. The factual background of this case. Hi, Adriana. All right, sweetheart. The factual well, strap in because we got fucking shit ton of pages to go. The factual background of this case has been detailed previously in this court's decision denying Giuliani's motion to dismiss plaintiff's complaint. See this. Summarized below is the factual and procedural history leading to plaintiff's pending motion for sanctions, including the entry of default judgment on their claims, which relief plaintiffs seek after 2 discovery hearings, 2 motions to compel productions filed by plaintiffs, and multiple court orders requiring Giuliani to explain his discovery conduct and comply with applicable procedural rules, for crying out loud. Giuliani has exploited these opportunities for delay, resulting in the extension of the fact discovery period by 6 months, unaccompanied by production of any meaningful discovery and response, all of which adds up to Giuliani's failure. Blah, blah, blah. All right, discovery issues leading. Okay, we're gonna speed this up. All right, so following Giuliani's answer to the complaint, a scheduling order was entered adopting the party's proposal that initial discovery disclosures be exchanged by May 18th and that all discovery closed by November 22nd, 2022. So it started over a year ago that they've been asking for the discovery. Okay. Blah, 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 blah. The 7-month discovery period proved insufficient, prompting the parties' joint request for additional time to complete discovery until May 22, 2023, a full 17 months after the filing of the lawsuit. After plaintiffs propounded their first set of discovery requests in May 22, Giuliani, through his counsel, advised plaintiffs that the Federal Bureau, the FBI, had seized his electronic devices in April 2021, which was delicious. Can we just say that was a delicious day? I remember it. Blah, 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 blah. Though his devices were returned no later than August 19th, Giuliani claimed he lost access to some of these accounts after the seizure. He forgot his password. And he and his counsel would need to assess the status of those accounts. Email from defense's counsel to the plaintiffs. Just kidding. Despite Giuliani's repeated reliance on the FBI seizure of devices to excuse his discovery, preservation, and production failings, responsive information held in his email and other communications related accounts could and should have been preserved, since the contents of these accounts presumably remained accessible online and through alternative devices. As to Giuliani's preservation obligations, Giuliani's counsel pointed to a data set held by Trustpoint One, which with assurances that this data set contained all the data collected by the FBI from Giuliani's seized devices. Blah, 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 blah. Between July 12th and November 1st, 2022, Giuliani produced to plaintiffs a total of 193 documents, in air quotes, all of which were sourced to the Trustpoint data set. Given the meager number of documents produced over 7 months of discovery, fairly small based on length of time, blah, 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 blah. Plaintiffs requested on December 21st, 2022, confirmation from Giuliani's counsel that Giuliani had taken reasonable steps to preserve his electronic evidence, blah, blah, blah. But the response was not encouraging. It just wasn't. Giuliani's counsel replied, "I'm not aware of his preservation efforts." What a great counsel he is. I want that counsel. Email from defendant's counsel to the plaintiff's counsel reiterated on February 6, 2023, that the request that Giuliani's counsel confirmed that Giuliani preserved, searched, and produced ESI on his email accounts, devices, social media accounts, messaging applications, or other electronic devices for documents responsive to the RFP, but received no response. Blah, 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 blah. Plaintiffs had the opportunity to query Giuliani directly about his preservation and search efforts at his deposition on March 1st. Giuliani testified under oath that he used multiple phones, email addresses, and messaging applications, and maybe a couple of different names, and maybe sometimes, I don't know, maybe he put on a tiara once in a while just to feel special. In the months following the 2020 presidential election. And Giuliani testifying that he typically has 2 phones and has a bunch of inoperative phones. I do too, girl. Though right now he really has officially only 1 phone, and he had a Gmail account and then several offshoot accounts like Rudy Giuliani at me.com and a Proton Mail account, and God knows his Madison account. No, he sent messages on Twitter too, Signal, Telegram, and WhatsApp, and don't check out his Gab. Around the time of the 2020 election, Giuliani described his search efforts as taking a quick look for responsive material on messaging platforms and some of his devices without providing any detail as to whether that quick search was tailored to the instant case or whether he ever reached out to any of the companies he used for messaging applications to ask that his data be preserved. Compounding this preservation failure, Giuliani claimed that his devices seized by the FBI in April 2021 were found to be wiped out when returned to him. Those fuckers. In accordance with the procedure set out by this court standing order to address discovery disputes promptly, Plaintiffs alert. Well, there's nothing prompt about this case. Plaintiffs alerted the court about concerns over Giuliani's apparent failure to comply with his discovery obligations, and a hearing regarding the parties' dispute was set for the 21st of March. At that hearing, in response to the court's question whether Giuliani had locked down, put a litigation hold on all of his records, given the pendency of this litigation, Giuliani's counsel stated, well, Your Honor, I think the answer is yes. I don't know. But certainly the documents were taken by the Department of Justice, were locked in April of 2021. So all of those documents are fixed. So that's certainly locked in. Giuliani's counsel also indicated that the TrustPoint dataset contained complete images of all data on Giuliani's devices seized by the FBI in April 2021. All of the files that were extracted were put into one server, which we then got a copy of from the DOJ. And that's with an electronic discovery vendor called TrustPoint One. So that's what we searched. This left unclear whether the TrustPoint dataset contained data from any of Giuliani's social media accounts or email or other messaging accounts. Let's see what this says. I don't know if this is in. Oh, wait. Whoa. Okay, wait. Let me read this. On June 29th, Giuliani's counsel provided plaintiffs with an unsealed motion filed by Giuliani's criminal counsel in some SDNY motion, which motion makes clear that the records collected in the TrustPoint database were collected as part of an investigation into possible Foreign Agents Registration Act violation involving Ukrainian officials, Ambassador Maria Yovanovitch, and the and the Office of the U.S. Ambassador to the Ukraine. A trip by Giuliani to Poland in 2019 and issues involving Franklin Templeton and funds misappropriated from Ukraine. This motion also contains Giuliani's criminal defense counsel request that the New York court order the government to suppress and destroy the majority of the records contained in the TrustPoint database and limit any remaining records to a time period between 2018 and 2019. What? Okay. At the March 21st hearing, Giuliani and his counsel could not provide clear answers when pressed for details about the TrustPoint dataset, including when they got access to this dataset or the specific device number or sources for or types of ESI in the dataset. Giuliani's counsel stating that his understanding was that all of the files that were extracted were put onto TrustPoint without knowing for certain what types of ESI were on the server and over what date range. Giuliani stating that he was not sure of when he first got access to the TrustPoint. Oh, interesting. Wow. Okay. Given the lack of clarity at the March 21 hearing in response to the queries about what precisely had been preserved or not and searched or not, Giuliani was directed, inter alia, that sounds so sexy, to submit a notice to the court describing in specific terms the data on the TrustPoint database that were searched in response to plaintiffs' RFPs, including the date range and contents, and what locations and data sources remain for searches to be completed to respond fully to plaintiffs' RFPs. Is it minute or minute? Is it like the time or the size? Time or the size? In response, Giuliani filed through his counsel a 2-page report, air quotes, on March 24th, which did not describe in specific terms the data sources located on TrustPoint or what locations and data sources remain to be searched. The TrustPoint server contained all files that existed as of the time they were taken in April 2021, all the way back for some of the devices to February 24th, 1995. I think all of his ex-wives are lining up to get access to that information, including email files, PDFs, images, Word files, as well as text and messenger files from messaging applications, without identifying which specific devices, computer, tablets, phones, and data sources, i.e. which messaging platforms and email accounts that the TrustPoint database's ESI encompassed, or whether TrustPoint held Giuliani's ESI for both his eponymous business and his personal files. Okay, let's see what this... Okay, I'm not going to read that. The March 21 order also directed Giuliani to complete searches and production of responsive records to plaintiffs' RFPs. Oh, wait. Marie, on August 30th, there will be a super blue moon. Yeah, I didn't look at my moon last night to see if it was blue. Did anyone else look at their moon? Please note it in the comments. Thank you. Super moon Wani. Here, yeah, right. Wani and Supermoon. Everybody in Supermoon, Marie. It's crazy. I mean, look at Giuliani. Okay, wait. Now I forgot where I was. Okay. File a status report by April 10th, apprising the court on their progress in resolving their discovery disputes and clarifying why they blah, blah, blah. On April 10th, the parties filed a joint status report in which plaintiffs explained that the parties are at an impasse with respect to Giuliani's document productions and requested a leave to file a motion to compel. Plaintiffs explained that while Giuliani provided them with a supplemental production that consisted of a single page, oh my God, which consisted to be 30 to 31. Oh, okay. Oh, okay, good. I'll look at it. Thanks, Paulina. Hi, Paulina. No, it's not your fault. It's my fault. Yeah, everybody be gentle with themselves and ignore all the bad people. God damn it. Okay, wait, this is really good. A single page with images of what appeared to be 5 direct messages from Sidney Powell on Twitter and claimed privilege over an additional 8 documents. His production was still plainly insufficient since Giuliani was relying on undefined manual searches of an unknown set of social media accounts, an undefined manual search of an unknown set of new devices, productions in response to discovery requests from a voting machine company in another civil case, Dominion, that had almost no overlap with plaintiffs' discovery requests, and a subset of the files in the TrustPoint database. Plaintiffs also raised questions about the universe of files in the TrustPoint database, explaining that Giuliani had never represented that all of the electronic devices he possessed at the time were seized by the DOJ in April 2021, or that all of the files from all of the devices seized are captured in the TrustPoint database, as opposed to some subset of documents responsive to a warrant and not minimized. Plaintiffs were granted leave to file a motion to compel. Wait. May 8th deadline, bitches! But guess what? May 8th came and went. So here we are to a May 19th hearing. Due to Giuliani's failure to articulate any specific steps he had taken to preserve his ESI, and they're then relying, just ask the FBI. That's what he said. Ask the FBI. They've got it. And the vague descriptions of the TrustPoint dataset and the searches conducted thus far, plaintiffs moved on April 17th to compel him to blah, blah, blah. And then what happened? He was supposed to, in response, Giuliani submitted his personal declaration about his efforts to preserve and search for records responsive to the plaintiff's RFPs. Blah, 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 blah. Giuliani reiterated that the TrustPoint 1 documents consisted of all documents that were easy for me to say, that were extracted from his electronic devices taken by the DOJ in April 2021, still failing to describe whether his electronic devices contained all responsive contents of his social media and messaging accounts, and thus whether those account contents were in the TrustPoint dataset. He further stated that he had used plaintiff's search terms to search email files in that dataset. Likewise, he used the search terms provided by the plaintiffs to conduct searches manually of all his electronic devices obtained after the April 2021 DOJ seizure for text messages, emails, and other documents, and all of his social media messaging accounts. And he separately also pulled everything related to any 2022 election issues from his paper files and files provided by Christina Bobb and Christiane Allen. Giuliani's description of his searches raised more questions. Hi, Nathan. How are you? Prompting the need for another hearing to clarify, among other matters, how the so-called manual searches were conducted and how drunk was he, and confirmed as thorough and accurate, whether the TrustPoint dataset encompassed all of his blah, 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 all that shit we're looking for. Oops, that's my soda can plunking. I need to take a drink. Hold on. Oh my God. Giuliani makes me thirsty. Okay. Giuliani also, for the first time, claimed that any further searches of the TrustPoint dataset, here's the best part, Any further searches of the Trust Point dataset would not be possible because those documents have now been archived, and it would cost him over, get ready for this, 320,000 smackaroonies to become current on his arrearage with Trust Point. How much is it a month to have access to the documents, as well as costs incurred in searching the documents for additional files? Yeah. Hmm. Hmm. But he did not have the funds to pay that amount at this time. Ooh, wow, ouch. No information was provided explaining when or why this data became inaccessibly archived, or whether the cost to obtain access to all the archived data could be less to examine only a subset of the data in a time frame responsive to plaintiff's discovery requests. I mean, really, work with me here, darlings. At a several-hour hearing on May 19th regarding the motion to compel, he acknowledged his obligation to preserve documents related to the litigation, and that this obligation arose before plaintiffs filed this action, stating, "I've been doing this for 50 years. I understand the obligations." When asked for the steps taken to preserve electronic evidence, Giuliani's counsel stated that Giuliani has not deleted any documents, Your Honor. Even though, as the court explained, not deleting documents is not the same as preserving the information in a manner that can be retrieved and searched, and not archived. Giuliani repeated his excuse for failure to preserve the responsive data, blaming the government's seizure of his devices in April 2021 for his purported loss of access to data created before that date. So there. Hi, J. Rance. Following the May 19th. Wait, I just need to check one thing. Oh, okay. I should make this like, let me do this. Wait, let me do this. Let me do that. You don't want that thumbnail. How come it, I don't hide the sidebar. Okay. Oh, that's so much better. Okay. Wait, where was I? Wait. Furthermore, in order to evaluate his claim of an inability to afford the cost of access to and search of the Trust Point dataset, or to use a professional vendor, Giuliani was also directed to produce to plaintiffs by May 30th full and complete responses to plaintiffs' requests for financial information and documentation to support his estimated costs for further searches on the Trust Point dataset. Giuliani timely filed a declaration. Declaration of Rudy Giuliani in compliance with court minute order, whatever. Giuliani, May 30th. Dated May 30th. This declaration summarized 6 different data sources as likely to contain or having contained at some point responsive information, including 3 personal email accounts, Gmail, iCloud, and Proton Mail. 2, another iCloud account. You just can't remember the passwords. 3 phone numbers, 2 turtle doves, and a Rudy fucked up. Okay, 3 phone numbers that he used to send messages via, I'm sure it's WhatsApp, text and messaging applications. Let's see if there's anything in here. Documents sufficient to show your yearly income since 2018 and your current net worth, including but not limited to your tax returns for the years 2018 through 2021, all periodic statements from January 20 blah, your other accounts, including but not limited to savings, money market, regardless of whether or not the account has been closed, including those held jointly, all insurance policies, any you're an officer, okay, any corporation you're an officer for, copies of all loan applications. Oh my goodness. Oh, you're in trouble, Rudy Giuliani. Yeah, we're keeping an eye on J. Rance. 5 social media handles. Giuliani social media accounts collectively. Giuliani communications accounts. And 9 devices, 2 of which were not seized by the FBI. Why is that? Adriana, we are dark and windy here, but fared well, thank goodness. Oh, Adriana, I'm so glad to hear that. Good, ladies, thanks for asking. We got lucky. It was a nasty storm. Oh, I'm so glad, J. Rance. I really am. And a partridge in a pear tree, and a Navarro in shackles. Okay. Okay. He also confirmed that his only step to preserve evidence on his devices and communications accounts was to turn off the auto delete function sometime in late 2020 or 2021 on his email messaging communication or other document storage platforms, and that he did not manually delete any electronic documents. Oh, okay. Well, that's under oath, honey. Finally, while reiterating that the TrustPoint dataset contained all documents that were extracted from the electronic devices taken by the DOJ in April 2021, Giuliani was notably silent as to whether that dataset contained all data from the Giuliani communications accounts and seized devices, only some subset of the contents of those sources, or no data from any of those accounts and applications, and what steps he took to preserve on the unseized devices, no data from which would be in the TrustPoint dataset because those devices were not seized by the FBI. Okay. Giuliani was required to produce by May 30th, 2023, financial information responsive to their RFPs and he sought reconsideration of this but he sought reconsideration of this aspect of the May 19th order, explaining that he has obtained funding to pay the arrearage with TrustPoint. Who paid that bill? To allow for full and complete searches responsive to plaintiff's RFP. So he did that on May. Oh, but he sought reconsideration. Oh, okay. When did he? Oh, okay. While Giuliani's obligation to respond to plaintiff's RFP was stayed pending completion of briefing on his motion for reconsideration, and in light of his representation that he has obtained adequate funds to get to the data, the court directed him by June, moving the goalpost. Directed him by June 16th to search and produce all materials responsive to plaintiff's RFPs, with the exception of the RFPs within the date ranges agreed to by the parties, with the assistance of a professional vendor, and produce a privilege log specifically tailored to the searches he has performed for materials responsive. They also granted Giuliani's unopposed motion for extension of time to produce it by June 30th. All right. Plaintiffs filed their combined opposition to his motion for reconsideration and response to his second declaration on June 14th. In opposition to his motion, plaintiffs argued that Giuliani's financial materials were relevant to both liability and punitive damages to show whether he earned any additional income or increased viewership or followers by making false statements against plaintiffs. Fun fact, he did, which is directly relevant to fault. With respect to the second Giuliani declaration, plaintiffs raised serious questions about Giuliani's preservation efforts, explaining that the declaration failed sufficiently to describe his efforts to preserve potentially responsive data and sources, and instead relies on whatever the government did with the devices seized in April 2021, which defendant Giuliani does not know and cannot describe. I think he can. I think he just doesn't want to. Plaintiffs also argued that Giuliani did not provide sufficient information for the court or plaintiffs to know what is or is not in the TrustPoint database, and that any explanation about efforts taken to preserve any of defendant Giuliani's professional files and ESI on his unseized devices. Due to these continuing discovery compliance gaps, plaintiffs sought to leave. So I'm the worst legal person in the fucking world, okay? Sought leave to file a motion for sanctions for Giuliani's failure to preserve ESI, which request was granted. Blah, 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 blah. In addition to the order, 3 successive orders granted plaintiffs requested relief in nearly all respects. First, upon consideration of the completed briefing on Giuliani's motion for reconsideration of the May 19th order, reconsideration was denied, and Giuliani was directed to produce responses to plaintiffs blah, 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 by June 30th. In second, plaintiffs' request for attorney's fees and costs associated with the filing of their motion and to compel was granted, and Giuliani was directed to pay those costs. But he hasn't. Plaintiffs tamely and timely detailed their costs and fees, explaining that the total costs incurred in preparation for their motion to compel amounted to $89,000, $172.50. Giuliani neither contested the reasonableness of plaintiffs' costs and fees nor filed any objection, and accordingly he was directed to reimburse them. But he didn't. As of the most recent joint status report, he has not. So there you go. As required by the May order, the party submitted a joint status report on June 30th, which report indicated, despite repeated court interventions, Giuliani was not taking the discovery orders seriously. Specifically, the status report stated that Giuliani had taken no steps to collect and search repositories outside of Trust Point, had produced no materials from the Giuliani businesses, notwithstanding his statement, subject to penalty of perjury, in his third declaration that he was searching for and collecting responsive materials from his eponymous businesses. See this. And only produced documents from Trust Point that appear to consist almost exclusively of non-usable, non-readable raw data. Notably, Giuliani did not contest these discovery shortcomings and failures to comply with the discovery. Does he have like Fozzie Bear as his lawyer? Like, who is his lawyer? Is it Weekend at Bernie's? Is that who his lawyer is? Just a corpse? Oh my God. Okay. In view of these generally undisputed continuing discovery failures, Giuliani was given another opportunity to comply with his discovery obligations and cautioned that a failure to comply with the May 31st order may result in severe discovery sanctions. July 13 order. Blah, blah, blah. Oh, okay, yeah, blah, 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 blah. Okay. The caution was not heeded. Shocker. Plaintiffs reported in the next joint status report that Giuliani failed to produce full and complete responses, blah, 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 blah. According to the plaintiffs, and undisputed again by Giuliani, who sits there like a bump on a log, Giuliani merely stating that this point is moot because he conceded all aspects of liability on which discovery from him would be necessary. Okay, can we just take that statement right there? Conceded all aspects of liability on which discovery from him would be necessary. So he just admitted he was guilty. Am I getting this right? I'm no lawyer, but I always wanted to be one. Giuliani's completed Trust Point production of 7,949 records consists almost entirely of non-usable, non-responsive materials. Oh, Jesus Christ. Consisting of approximately 4,142, or more than half, as indecipherable blobs. That is my next Twitter handle. Indecipherable blob. Oomph, I hope you're here. The stork came. Oh, that's a beautiful baby. That's a beautiful wait for your baby. Oh, Jim, congratulations, Grandpa. I hope you have so much fun. Out of the remaining 3,807 documents, plaintiffs identified only 188 documents that might be relevant to their claims, but 63 of those documents consist of text with what appear to be wiped bodies, leaving just 124 potentially relevant documents. I think the indecipherable blobs was just a phrase I thought was interesting. Oomph, that's all. Yeah, congratulations, Jim. Grandbaby came and looks really healthy. 7 pounds, 14 ounces. Oh, that's right. Yeah. Well, healthy baby. Good. That's a wonderful size. Let's see. Blah, blah, blah. Yet plaintiffs' counsel identified only 50 or fewer documents out of those 124 records that were directly relevant to plaintiffs' claims. And the majority of those were unremarkable documents, such as meeting emails, querying the location of Zoom links, or copies of publicly available documents. Julie Giuliani's compliance with the May 31st order also remained deficient, apart from his 2018 tax returns and the stipulation of settlement from his divorce proceeding in 2019, and the additional documents from the 8,000 records from Trust Point. Giuliani failed to produce any additional records responsive to plaintiffs' RFPs, including any documents from his electronic devices and sources of discoverable information after April 2021, so the unseized devices, nor any responsive records from the Giuliani businesses. Jesus Christ on a cracker. Oh, about 3 kilograms? Oh, okay. Okay, we might go through this pretty fast because it's just about the businesses. Directly from the Giuliani businesses, but without any response. Consequently, in June, they moved to compel the businesses, serve subpoenas. Giuliani has failed to respond. He was given another opportunity. Giuliani said he didn't oppose the court's show cause order as to why the businesses should not be granted. Does not oppose the court show. Oh, plaintiffs, Giuliani businesses motion should be. Okay, I got it. Yeah, I think my brain's going. Okay, I think I need to smoke. Hold on. Let's take a little minute. Okay, I'm back. All right. Blur, 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 blur. Given that he was the sole owner of the businesses, third Giuliani declaration, and had otherwise failed to secure businesses compliance with. How do lawyers read this? You throw all this shit in the middle of a perfectly good sentence. Jesus Christ. I think you guys do this just because you want to feel important. Yeah. Okay. That's what I have to say about lawyers. Okay, wait. And had otherwise failed to secure or respond to the plaintiff's business motion, Giuliani was directed personally to pay the plaintiffs their reasonable costs and attorney's fees incurred in preparing and filing the motion, with the remainder of plaintiffs' requested relief reserved pending resolution of the plaintiff's instant motion for sanctions. Even with the requested entry of default against Giuliani, plaintiffs still seek discovery from the Giuliani businesses showing the metrics and income generated from the show Common Sense, particularly those episodes that contain false statements. Oh, well, strap in, because there's quite a few of those shows. Because such evidence is probative of the quantification of damages, as well as 3 rule something or other depositions from the businesses, for which, to date, defendant Giuliani has failed to identify a corporate representative. Why isn't he the corporate representative? I mean, okay. He should have Ted do it. His little buddy. Okay, via their registered agents to produce documents relevant to litigation and to meet and confer and designate corporate representatives. Okay, but receive no reply. Okay, let's see what else we got here. Okay, so they did another order for attorney's fees on August 4th of this year for $43,000 in addition to the $89,000. So we're up to $130,000 now, $135,000 if we're going to be honest about it. Blah, 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 blah. See, the lawyers throw this shit in there, and I try to read it as if it's a sentence, and it's not a sentence. So, yeah. Precision matters. Yeah, it does. It's true. All right. Giuliani raised no objection to the reasonableness or amount of attorney's fees plaintiffs requested, but rather contended that he may not be held personally liable for the $43,000 without a proper finding that there is an alter ego and veil piercing can be appropriate between him and his eponymous businesses, citing the fact that plaintiff's motion to compel was made against and only granted to his businesses and not to Giuliani himself. Plaintiffs, in response, largely sidestepped the issue of alter ego liability, instead asking that the July 26 order be modified to direct the businesses to comply with the order and pay the fucking fees, which defendant Giuliani should be held personally responsible for ensuring occurs because he failed to cause the businesses to comply with the plaintiffs. Blah, blah, blah. You nerds. I love it. I wanted to be a lawyer so much when I was a little kid. I don't know what happened. Then I took Russian and I was like, oh, I could do this. It wasn't smart. Okay, let's see if this was anything. With respect to the document requests, quantification of damages, material. Okay, so they're going to use they need all this discovery in order to figure out how much fucking money they're going to get from him, which is the best. Okay, so anyway, blah, blah, blah. I don't think that doesn't look very interesting. Lots of gobbledygook here. Lots of fucking numbers and ampersands and periods and Jesus. This is why lawyers get paid so much money. Is that the footnote about Ellis and the other one? Wait, is it? Oh shit, is it? I don't think it is. Giuliani businesses. No, that's not. It's going to be the Ellis one. In view of Giuliani's deficient discovery compliance, and after Giuliani informed the plaintiffs on July 10th through counsel that he did not agree with the key principles of a potential settlement agreement negotiated by his attorney. Oh, so his attorney, Weekend at Bernie's tried to negotiate a settlement for him, and he said no. Okay. I think PLS should be pleased. I'm just going to submit that to the legal community that I think PLS should not mean plaintiffs. Although I want to just tell you, I guess that that's what it meant, and I'm pretty fucking smart. I guess, maybe I am a lawyer and I just don't realize it. Anyway, plaintiffs filed the pending motion to sanction defendant Rudolph Giuliani for failure to preserve electronic evidence, seeking severe sanctions, including inter alia default judgment. In response, Giuliani submitted a personally executed and unsworn stipulation. Jesus fucking Christ. In response, Giuliani submitted a personally executed and unsworn stipulation that purports to concede all factual elements of plaintiff's claims for the purposes of this litigation. This just seems like a terrible bad idea, doesn't it? MSW, she did submit SMT, something about a footnote. Oh, I think I know what you're talking about, Marie. I'm sure we'll get to it. I think we'll get to it. We're still we're only halfway through. At the same time, this stipulation contains the following caveats and limitations, undercutting the factual concessions, including the stipulation does not affect his argument that these statements are constitutionally protected statements or opinions, or that plaintiff's claims are barred by any applicable statute of limitations. That's all so dumb, and is subject to any retained affirmative defenses not expressly waived herein. So basically, is he just saying, yeah, bend and snap? Is he basically saying that it's not, wait, the stipulation says I may concede to all of their claims, but that doesn't mean that I don't get to say them, and that they didn't bring it in time to be mad at me anyway. And lastly, whatever else would get me off, Judge, whatever else you think would get me off and make me an innocent man, I think that's what I'd like you to consider as part of my motion. It's not the motion of the ocean, it's the crashing of the waves. I thought of that this morning. Actually, I thought of no, I did say that. It's not the motion of the ocean, it's the crashing of the waves. It's where the waves crash. Okay, I'm sorry. Like you guys are, it's your fault. Okay, blah, 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 blah. Here we go. Well, no, not necessarily, but let's just read this anyway. It looks good. Giuliani's response also included a declaration from Robert Costello, Giuliani's counsel. No, it isn't. It's Abbott and Costello is his counsel in connection with the FBI seizure of his electronic devices. The declaration, which, along with casting aspersions at the plaintiff's counsel, did you see how big his butt was in that suit? Attempts to rebut the contention that Giuliani intentionally spoliated. Oh, yeah. Fuck yeah. I'm getting hot. Like, I'm getting excited reading this spoliated or destroyed evidence. Illuminating. This judge, whoever wrote this, fucking peak perfection. Legal porn. Illuminating in this declaration is the description of the review process applied to the data extracted from Giuliani's seized devices. That extracted data was stored on the government's electronic discovery vendor called Pay, and then funneled for privilege review through a special master Bader, who would contact Abbott and Costello and inform them that she would provide and make preliminary claims of privilege for any electronic document provided to my pussy. No, I'm sorry. And he fucked her right in the pussy. No, I'm just kidding. Sorry. It's a joke. It's a joke. It's a drag joke. Okay. And those documents identified, but oh yeah, right. Wait, what? This process, as described in the Costello Declaration, suggests for the first time that TrustPoint held merely a subset rather than all. Oh, so now we know of the records on Giuliani's seized electronic devices, which is inconsistent with Giuliani and his counsel's repeated representations in this case that the TrustPoint dataset contains all data on his seized devices. So basically, can we now admit Like, at what point do you get in trouble for actually lying? When does I mean, I guess it's coming, but it seems like it takes a long time for you to get in trouble. Okay, here we go. In any event, this thing indicates that more than the 95% of the electronic materials reviewed on TrustPoint, Costello cannot recall. I don't remember if plaintiff in all of the materials that he reviewed. Wait, recall any mention of either plaintiff in all of the material. Wait, I don't even understand that. Okay, fuck. You need a law degree? He's bullying it. I know, I hate it. And then he spoliated all over the place. Um, okay, wait. And that fucking sentence doesn't make sense. I don't care what fucking law school you went to. I don't fucking understand. Though whatever reassurance that is supposed to provide is severely undercut by the fact that the responsive information to the warrant was limited in time to August 1st, 2018 to December 31st, 2019, many months prior to the events relevant to the plaintiff's claims. When the devices were finally returned to Giuliani, the Costello Declaration repeats Giuliani's assertion that all the devices have been wiped clean by the vendor for the government. Really? Really? Really, Greece? And your iClouds? Really? But without any verification of this fact by any expert forensic examiner or even a professional information technology professional or that guy that changes my watch battery at the mall. Given the seemingly incongruous and certainly puzzling caveats contained in the Giuliani stipulation, this court directed Giuliani to provide a superseding stipulation in which he concedes, for the purposes of this litigation, all factual allegations in plaintiff's amended complaint as to his liability for we were doing so well. Hi, Max. On plaintiff's claims and liability for punitive damages and concedes that entry of default judgment on liability is appropriate in this case, or provides an explanation for declining to submit the superseding stipulation. Okay, is it minute or minute? Minute or minute? It's fine. I don't need to know. Okay. The superseding Giuliani stipulation remains nearly as puzzling as his first, however. Again, Giuliani concedes for purposes of this litigation only, as if that really is going to make a fucking difference. Like minute, like a minute of a day, or minute, like small, or insignificant. Okay, wait. For purposes of this litigation only, all factual allegations in plaintiff's amended complaint as to his liability, but not for all damages allegedly caused by him. What? For plaintiff's defamation. So I'm guilty, Your Honor. But can I just be guilty of a little bit? Can I just say I'm guilty and then I don't have to actually pay anybody for that? Is that it? Are we cool? We're cool, Judge. I'm out. Are we cool here? We're cool here, right? We're all set? I'm all set. Okay. Holy shit. This is pretty good. For plaintiff's defamation, intentional infliction of emotional distress, and civil conspiracy claims, and his liability as to plaintiff's claim for punitive damages. Yet, Giuliani again asserts that he believes that he has legal defenses to this complaint that he seeks to preserve, including his arguments that the statements complained of are protected and non-actionable opinion for the purposes of the appeal. He literally put these women's lives in danger. He fucking deserves to die in prison, and I really fucking hope they put him in Rikers, and I hope he's in regular Gen Pop. I fucking hope they put Rudy Giuliani in Gen Pop in fucking Rikers. I really do. I'm sorry. Sorry, not sorry. Time. Okay. Minute, which is probably more like distinctive, I would imagine, not small. Very tiny paper. Very tiny paper. Very tiny. Very tiny. See, wouldn't I be fun? I should be a paralegal. Okay, wait. What? In support of the attorney's fees and costs. Okay. Applicable procedural rules. Oh, this is part we probably won't read this. Okay, let's be honest. But we'll just go through some of them. Okay, the federal civil procedural rules authorize the imposition of sanctions for the failure of a party to a civil lawsuit to preserve ESI and to comply with the court's discovery orders. And honey, let's talk about how you do not comply with the court's discovery orders because, girl, oh, a party to federal litigation that is either anticipated or pending is required to preserve potentially relevant evidence. Blah, 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 blah. Here's all the rules. Similarly, serious sanctions and just orders are authorized if a party fails to man, this is not easy. I think I'm not high enough. I don't think it's that I'm high. I'm not high enough. Fails to obey an order to provide or permit discovery, including an order under rule blah, 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 blah. Okay, so the sanctions especially authorized, including attorney's fees, and you're gonna have to run down the street naked. Okay. Plaintiffs contend that the sanction of entry of default is warranted. Yes, it is. Additionally, plaintiffs' request discovery relief from the Giuliani businesses will be granted as the plaintiff's request, despite Giuliani's attestation that Giuliani Partners LLC has no assets. And Giuliani Communications LLC has only media equipment assets, including 3 microphones, by the way. In case you haven't seen Rudy Giuliani's Common Sense, which is the most ridiculous name for his podcast I've ever heard. But if you've ever seen it, he has 3 microphones on his desk. I don't know why. Because, frankly, his sound is not that good, so I'm not sure what good that's doing him. But anyway, I digress. Blah, blah, blah. Sanctions. Spoliation. Sanctions under Rule 37E are warranted when 1. ESI should have been preserved in the anticipation or conduct of litigation. 2. A party failed to take reasonable steps to preserve the ESI. 3. ESI was lost as a result. And 4. ESI could not be restored or replaced by additional discovery. In other words, son, you're fucked. Giuliani should have preserved electronic evidence. First, as plaintiffs correctly argue, please, MTC at 17. Giuliani should have preserved his ESI well before the filing. I know, we talked about it a lot. Okay, we're looking actually now for the Ellis thing. So whoa. There's some quotes in here. First, as plaintiffs correctly are, because you just can't get away without reading every goddamn fucking section of this thing. First, as plaintiffs correctly argue, Giuliani should have preserved well before the filing of this lawsuit. Once a party anticipates litigation, it must preserve all potentially relevant evidence that might be useful to an adversary. Meet mop moot. Giuliani admits in his second declaration that he received notice of potential litigation issues surrounding his involvement in contesting the 2020 election in late 2020 or early 2021. I don't remember. Second Giuliani declaration, paragraph 2. His duty to preserve ESI relevant to plaintiffs' claims thus began at least by early 2021, as well before plaintiffs filed suit in December of 2021, and likely before the FBI seized his electronic devices in April 2021. See this shit. Quote, I have about 20 preservation orders, much of which overlaps with this. So I started, preserving from way before the case. Thus, Giuliani had a duty to preserve potentially relevant ESI on the Giuliani devices and Giuliani communications accounts by at least early 2021. But he didn't. Spoiler alert, as we've been discussing, he didn't. Second, plaintiffs argued that Giuliani's efforts to preserve his ESI, turning off auto-delete at some unidentified date on an unenumerated number of his devices and communications accounts were not reasonable. No shit. The scope of an order recorded in the minutes of the court rather than directly on a case docket. So it's minute, like time. Okay, a minute order. Oh, okay. I was right. I thought it was minute. That's why I never got into law school. That's why I never passed the LSATs. The scope of a party's preservation obligation can be described as follows. Yeah, right, Jim? Why? Just just buy hookers and drink brandy and tell stories of the days of yore. That he had it. He had it figured out. Do. Once a party reasonably anticipates litigation, it must suspend its routine document retention destruction policy and put in place a litigation hold to ensure the preservation of relevant documents. Zubulake versus UBS Warburg LLC. Yeah, all these other numbers. A party must put in place a litigation hold. Okay, we said it once. You don't have to say it 17 fucking times. Oh, or maybe you do. I know that's a legal thing. I'm just kidding. With respect, okay, blah, 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 normally held that litigants must prevent destruction. You know, he didn't do any of this. Oh my God. The relevant defendant's failure to prevent destruction by backing up their phone's contents or disabling automatic deletion functions was not reasonable because they had control over their text. Oh my God. This guy is so fucked. If he has any money left, he's not going to have anything left. He's going to need prison for 3 hots and a cot. You know what I'm saying? Disparage nerd. I love nerds. I'm a nerd myself. I'm just saying there's a lot of numbers, okay? I don't think it needs to be this complicated. No, I know. Lawyers have to put a lot of fucking supporting shit in there. I get it. Or judges. I don't know. Lawyer. I don't know. Plaintiffs are right. Law clerks, I guess. Law clerks, really. Let's be honest about who wrote this. Plaintiffs are right that Giuliani did not take reasonable efforts to preserve his ESI. His summary of his preservation efforts amounted to turning off auto-delete sometime in 2020 or 2021. Okay, blah, blah, blah. We already read that. As plaintiffs correctly point out, Giuliani's representation in his second declaration of my independence lacks the kind of details that would make it worthy of credit. He's down. He is down. How he turned them off, if so, or when, whether he did so or tasked someone else, Ted did it, and whether he sought to recover any records from his various online accounts confirming these changes. Please, FTC at 18, emphasis in the original. Nor has Giuliani clarified the scope of his preservation efforts in his opposition to plaintiff's motion. Merely turning off auto-delete on each of the devices and then the accounts is also insufficient. He could have, but he chose not to, taken any other reasonable steps to preserve his ESI, such as backing up his iMessage communications, using your iCloud. Let's see, anything else? This seems like a lot of words. This is the first time I've stuck in rush hour traffic since. Oh, really? Wow. Come to Los Angeles. We've got plenty of traffic. The fact that Giuliani is a sophisticated litigant with a self-professed 50 years of experience in litigation, including serving as the U.S. Attorney for the Southern District of New York, only underscores his lackluster preservation efforts. Oh, ouch. Noting that courts should be sensitive to the party's sophistication with regard to litigation and evaluating preservation efforts. Some litigants, particularly individual litigants, may be less familiar with preservation obligations than others who have considerable experience in litigation. Giuliani knew, by his own admission, that he would be facing litigation for his involvement in claiming election fraud to undermine the results of the 2020 presidential election, and yet all he did was turn off the auto-delete function on unspecified devices without alerting the service providers of those platforms to do the same. I don't even know what WhatsApp is. What's Signal? Accordingly, Giuliani failed to take reasonable steps to preserve. Blurp, blurp, blurp. He doesn't seriously contest that he failed to take these reasonable preservation efforts. In fact, he says, "It's me. I did it, darling. I'm guilty as sin. Lock me up because I need lunch." Giuliani's efforts to shift blame to the government does not withstand scrutiny. The Costello Declaration suggests the following critical points. First, that the government's vendor, PAE, pay, not trust point, contains the full extractions or images of the seized devices and thus any pre-April 2021 ESI stored on those devices. Second, that data was only transferred to TrustPoint to facilitate Costello's review for potential privilege claims at the direction of the court-appointed special master, who identified responsive but potentially privileged information to the warrant, which was focused on potential FARA violations limited in time to August 1st, 2018 to December 31st, 2019. And finally, that the data transferred by pay to the trust point was not, in fact, all corrupted, since Costello states that he was able to designate certain communications that he believed were covered by attorney-client work product or executive privilege for the special master to review. Well, I can't see what they say, Judge, but I'm pretty sure that they're privileged. These points made in blah, 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 blah. Yeah, everybody's lying. In any event, even had the government corrupted, wiped, or otherwise lost his pre-April 2021 ESI, his reliance on the government's execution of a search warrant as the most significant preservation effort taken to preserve his pre-April 2021 data only confirms that Giuliani did not himself engage in any, unreasonable steps to preserve his blah, 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 such as backing up the data. I mean, it's not hard. Simply put, he fucked up. The government is not Giuliani's ESI preservation team. So there. Oh, and his lawyer undermines his position in two other respects. What a great lawyer he is. First, the Costello Declaration settles that prior to plaintiff's filing of this lawsuit, Giuliani and Costello knew the trust point data set. Whether or not this data set encompassed all his pre-April 2021 ESI contained some corrupted files, but did not ever attempt to preserve or recover or coordinate with pay or trust point or the platforms hosting the communications accounts to preserve or recover any of that ESI. Second, even if the government wiped his seized devices, as they assert, that assumption says nothing about Giuliani's unseized devices and does not explain why Giuliani can no longer access ESI in the Giuliani communications accounts, since he would be able to access that data on the cloud networks for each account had he taken reasonable steps to preserve this. He forgot his password. His password is gone. Oh my God, it's irretrievable? No, that's not true. Given Giuliani's much vaunted experience, he plainly should have known better, and had he taken the proper steps prior to or even after the FBI seizure of his devices, his potentially relevant ESI could have been preserved. So there. Not good enough, sir. Giuliani's ESI is now irretrievable. Plaintiffs argue that the third requirement for a finding of spoliation, hey, it's been spelled different ways. What's going on with that? Is met because Giuliani's blah, 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 is irredeemably lost. Irremediably lost. I have never heard of that. Giuliani has conceded as much to his seized devices, and in any event has stated that he need not produce any additional discovery because he has conceded all aspects on liability on which discovery from him would be necessary. I already said I did it. I'm just not going to pay for it. ESI is irretrievable when it cannot be restored or replaced through additional discovery. Because ESI often exists in multiple locations, loss from one source may often be harmless when substitute information can be found elsewhere. So there you go. So in Borum, for example, an employee's emails were deemed irredeemably lost. Irremediablement. Wait, where is it? I want to say it like that. Irremediablement. I like that better. Irremediablement. Am I saying it anywhere close to right? Okay. All right. Similarly, Giuliani has repeatedly admitted that his ESI has been wiped from the seized devices or he has lost access to his communication accounts. I don't have any. I can't. Oh, thank you. No remedy. I can't say it. I can't say it unless I'm really like looking at it and reading. Okay. Giuliani noting that 90 to 95% of his communication is done on Apple and it's backed up by the iCloud, but he doesn't have access to the iCloud anymore without explaining why. I am telling you right now, part of what pisses me off about this stuff is, or what pisses me off about due process. Can I just say that? Can I get a little spicy here with due process? My little spicy with due process is that the longer we wait and the longer these processes take, the more time these morons have to destroy evidence. Now, I know Giuliani is not smart enough to destroy all the evidence of his crimes. So good news. But that's my only complaint about due process. Okay. Given the threshold, the requirements are satisfied. The only issue left to decide is whether sanctions are warranted. The rule authorizes district courts to order measures no greater than necessary to cure the prejudice, or upon finding that the party acted with the intent to deprive another party of the information's use in the litigation. Then presume that the information was unfavorable to the party, instruct the jury that it may or must presume the information was unfavorable to the party, or dismiss the action, or enter a default judgment. So I have a question. So the judge in this case made the default judgment without it going to a jury. Does that mean that there is a greater chance of overturning it on appeal? Or I'm sure that's probably not the case, but I just kind of wonder. Plaintiffs have been prejudiced by Giuliani's failure to preserve ESI. Yes, they certainly have. Okay. To evaluate prejudice from the loss of ESI, courts consider the information's importance. I mean, the information here is everything. It's what he said about them over and over and over again, and the defamation. It's relevant to all the claims. First, as explained in Freeman, if plaintiff Ruby Freeman is a limited purpose public figure, as Giuliani argued, she would have to show that Giuliani's statements about her were made with actual malice, which would require Freeman to prove that Giuliani published false statements concerning her with knowledge that it was false, or with reckless disregard of whether it was false or not. Whether Freeman was a limited purpose public figure was not resolved in that decision, but if she were, plaintiffs would have to prove that Giuliani made the false statements about her with an awareness of falsehood, meaning that they would have to prove the defendant's state of mind through circumstantial evidence. Without access to circumstantial evidence of Giuliani's state of mind in the form of his messages and email communications with associates, or other contemporaneous records of his thoughts when he made the false statements against Freeman, plaintiffs are severely hampered in being able to refute Giuliani's defense that he made his statements about Freeman merely negligently. This is so good. Second, plaintiff's claim for intentional infliction of emotional distress requires a preponderance of proof that Giuliani engaged in extreme and outrageous conduct, which intentionally or recklessly caused them to suffer severe emotional distress. Similar to Giuliani's public figure defense to Freeman's defamation claim, plaintiffs will be severely hampered in proving that Giuliani acted intentionally or recklessly without access to circumstantial evidence of his state of mind. Oh, bitch. Thank God it's another inter alia. Finally, to prevail on their civil conspiracy claim, plaintiffs must prove inter alia, an agreement between two or more persons to participate in an unlawful act. Buddy's fairly informed analysis reads, this is a pretty, excellent. Very glad to hear that. Very glad to hear that. Such proof rests on evidence that Giuliani worked with others to defame and inflict emotional distress on plaintiffs, but due to Giuliani's failure to preserve and produce his communications with others concerning plaintiffs and the surrounding context, plaintiffs are again severely hampered in establishing this claim. Or secure, from appeal, or secure against being overturned. Yes. Okay. Well, I guess that's why they put in all the extra examples, huh? Yeah. Okay. All right. Okay. Number salad. Okay. Well, that's the reason for the number salad then. Plaintiffs have also shown through discovery obtained from third parties that had Giuliani proper. I'm so sorry, everyone. I can't speak today. that had Giuliani properly satisfied his preservation and production obligations, he should be in possession of documentary evidence that goes to the heart of the claims in this lawsuit. For instance, plaintiffs received not from Giuliani, but from third party Christina Bobb responsive records, including a text thread between Bobb and Giuliani discussing sending a video of plaintiffs to Rusty Bowers, then the Speaker of the Arizona House of Representatives. December 4th, 2020. Oh, wait. A direct message between Giuliani and Bob on Instagram. Instagram. The fuck? Concerning plaintiffs. An Instagram message between Bob and Giuliani. Oh, God, I'm sorry. A text thread between Boris Epstein. Oh, my God, another guy I love. An advisor to the 2020 Trump campaign and a lawyer. And Giuliani and others, in which Epstein states, urgent POTUS requests need best examples of election fraud that we've alleged that's super easy to explain. Doesn't necessarily have to be proven, but does need to be easy to understand. Oh, Jesus Christ. To which Giuliani replies, the security camera in Atlanta alone captures the theft of a minimum of 30,000 votes, which alone would change result in Georgia. Remember, it will live in history as the theft of a state if it is not corrected by state legislature. December 7th, 2020. Before the December 18th meeting. Okay. Plaintiffs also received not from Giuliani, but from third-party Christiane Allen, one of Giuliani's assistants, responsive records, including a December 7th, 2020 email from a Fox News reporter to press@GiulianiPartners.com seeking a comment from Giuliani regarding the Georgia Secretary of State chief investigator's debunking of Giuliani's claim that plaintiffs were pulling suitcases filled with mystery ballots from under tables while tabulating the votes on election night. Oh, from Ron Blitzer. Oh, okay. Ron Blitzer. Who's Ron? Okay, never mind. According to plaintiffs, one of these communications were produced. None of the. Oh, Jesus Christ. That's a misread. They and my confidence in them could be wrong. Much of this thoroughness shows. Well, I mean, that's the thing. Yeah, it shows. Yeah, I can appreciate that. That the more obviously that is clearly they're creating as tight a case. It's just curious. It is curious to me how the lack of a jury, like a bench trial, how that changes things. But maybe I don't claim to understand any of this. So excited to find out. According to plaintiffs, none of these communications were produced by Giuliani, who has claimed no privilege over these communications. Additionally, plaintiffs say they have additional examples of relevant documents and communications obtained from third parties that were not produced by defendant Giuliani. This might be the indeed, the U.S. House of Representatives Select Committee to investigate the January 6th attack on the U.S. Capitol released a December 13th, 2020 email from Giuliani to Boris Epstein, in which Giuliani approved a statement from the Trump legal team that stated Georgia has video evidence of 30,000 illegal ballots cast after the observers were removed, referencing Giuliani's false claim made about the plaintiffs. Yet Giuliani never produced that email to plaintiffs, nor, as far as plaintiffs' counsel can discern, did he ever claim privilege over it. In defense, Giuliani argues that just because third parties, but not Giuliani, were able to produce responsive records does not prove that he had any access to those same materials and lost or destroyed them. To be sure, missing some responsive documents or communications does not in itself prove spoliation, but the record here with multiple third parties, all producing responsive communications with Giuliani that he failed to produce, certainly demonstrates the deficiencies in his preservation of ESI or his search methodology. How can this many attorneys be ignorant of the law? This is almost like a real life Emperor's New Clothes. Well, I think it's Weekend at Bernie's. I think that Costello is just a warm body. He's not really a lawyer. I mean, he's as much a lawyer probably as I am. No, I'm just kidding. He probably is a lawyer because he couldn't even go in there if he wasn't, for crying out loud. Oh, wait, what am I doing? Oh, boy, I just totally missed that. Testimony from Giuliani and third parties also suggests that responsive, but now either lost or certainly not produced ESI should exist in the Giuliani communications accounts and on the Giuliani devices. For example, Giuliani testified that he talked to many people who said that poll observers were excluded from the State Farm Arena in Fulton County, Georgia on election night in 2020, and that there were constant complaints about that. Bob similarly testified that Giuliani was getting like 10,000 emails a day, like for sure. during the time period in which Giuliani was challenging the results of the 2020 election, and that she was copied on certain incoming emails to ensure that those emails were brought to Giuliani's attention. Additionally, Bernie Carrick, a key investigator for Giuliani and flipping like a pancake, testified that Giuliani and his team were receiving reports of possible fraud from 100 different sources during the November and December 2020 time period, with tons of information coming to Giuliani and his team. Little to none of those estimated thousands of emails from 100 different sources have been produced to plaintiffs by Giuliani. His failure to preserve has significantly prejudiced plaintiffs' abilities to prove their claims, because circumstantial evidence of his knowledge of the falsity of his claims concerning plaintiffs would have likely existed in his lost ESI. Bleep, blah, blue, bleep, blah, blue. But the third-party discovery and testimony from Giuliani, Bob, and Carrick suggests that evidence concerning when Alan, I would think. Alan, Bob, and Carrick. Did I find a mistake in this motion, this order? Giuliani obtained information relevant to his investigative, verified, presented, and characterized such information to others, and how he pushed that information to others likely existed, even if not currently extant, on his devices and in his communication accounts. Okay, I am Noelle Dunphy. Oh, and here's the thing. Oh, I had a question about that, Marie. So Noelle Dunphy is the assistant that is suing Giuliani for sexual assault or sexual abuse or a number of different things. He was absolutely disgusting. If you haven't caught up on that case, she was horribly mistreated by him and abused. So her court case is going on, and I am very interested to hear, because I haven't yet heard the same ESI claims. I don't know, is that case started? And now I'm doubting myself. I need to know if that. Hi, Nancy. Okay, Giuliani intended not to take reasonable steps to preserve his ESI. I remember she had access to it. Yeah, of course, she would have had all kinds of access. So maybe a lot will come out. Maybe, anyway, okay. Okay, this is all preservation efforts. We already really went over the fact that he doesn't fucking know how to do anything. Sanctions. He's failed to comply with other court-ordered discovery obligations. Okay, so this is a little, I'm sorry, it's a little boring. The financial records, order to pay. Yeah, he needs to pay like $140,000 in attorney fees and costs associated with their instant motion as sanction. Okay, and what my understanding from watching Michael Popak on Legal AF, when he was talking about this morning, he said that they will do what they can and then use it all to determine the amount of the judgment, and that she's going to be, I guess Beryl Howe was the guy. He's going to give them, I know it's gross, Jim. It was really gross. The judge is going to be really specific with the, I guess, jury that determines the settlement damages about what to consider. So he's really trying to take care of Ruby Freeman, make sure they get their justice. As explained in more detail below, plaintiffs are right that under either or both rules 37 E2 and B2, entry of default judgment is the most appropriate sanction in this case. So therefore, I'm going to do it. In addition, his continued non-compliance without excuse or explanation will be sanctioned by precluding him from relying on any assets or net worth documentation not turned over by September 20th, 2023. And by issuance of adverse instructions at the trial on plaintiff's damages. Oh, fuck. I'll try and find that footnote. Will be granted. The attorney fees and costs associated with the filing of the instant motion will be granted. Blah, 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 blah. Entry of default judgment. They're going to get all kinds. Well, I mean, I hope they get their money before he shits the bed. I think he's going to shit the bed before he goes to prison. That's my guess. I'm just saying. The web justifications support entry of default. Okay, this is all the stuff. This is the meat of the matter. This is si poblete. Third, he repeatedly flaunted his discovery obligations. De minimis. I love the law. I should have been a lawyer. God damn it. His choice to make no effort to comply with the May 31 or file his two stipulations prior to the June 30th can be seen as nothing else than ignoring this court. Giuliani would love to have his proverbial cake and eat it too, like a little child. He wants to bypass his discovery obligations now with stipulations that would leave him somehow free to raise his affirmative defenses to plaintiff's claims on appeal with a record predicated on deficient discovery. Yeah, I mean, that's, that actually is going to be, yeah, I bet that wasn't exclusive. That I think is going to be, I think his appeal is going to be like, oh no, it's too late, Max. I have no desire to work hard. I have no desire. I can't. It's too late. It's definitely too late. I don't want to be one. I want to pretend. No, I don't want to pretend. I'm not pretending. I just like to read like one. I like to be one while I'm reading. Okay. So default lesser sanctions will not deter the conduct. Oh, okay. Well, that's true. Yeah. Plaintiffs are entitled to attorney fees and costs for bringing the instant motion. Yeah. So they're going to get all kinds of like attorney's fees. That's the first 90,000. Then he owes them 43,000, and then he owes them more. Okay, wait, this is all stuff we went over. I'm so sorry. Yeah, I know. I understand. Giuliani's claims. Giuliani, he has recently listed his 3-bedroom apartment in New York City, $6.5 million. 6.5 million. And when recently traveling to the Fulton County Jail in Atlanta, Georgia, in connection with criminal proceedings against him, Giuliani is reported to have flown on a private plane. In short, based on the current record, Giuliani has failed to show that he cannot pay the reimbursement fees he owes. Ouchie McGouchie. He's going to get it. He's going to get it in the pocketbook. Good for her. Oh, God, you know what? I just wish he had more money so that all these women could get paid. Is that bad? I hope he has enough money to pay all these women what they're due. God, man. Fucking man. Okay. Second, as a sanction for failing to comply with and instead ignoring the June 22nd and July 13th orders, the jury will be instructed that they must, when determining an appropriate sum of punitive damages, infer that Giuliani is intentionally trying to hide relevant discovery about his financial assets for the purpose of artificially deflating his net worth. Oh boy. While case law overwhelmingly favors using a permissive rather than mandatory instruction, in special circumstances, a stronger inference may be warranted. And this is where the judge says, oh no, you're going to pay. Plaintiffs are entitled to certain discovery, limited 30, and yeah. I think he hid money abroad. Yeah, he does, Marie. Plaintiffs are entitled, okay, so the discovery, documents showing metrics and income. This is the metrics about his social media accounts and his podcast. He basically has shown them nothing of the discovery that they wanted. This is crazy. Giuliani will be directed to ensure his businesses fulfill their court-ordered discovery obligations. Okay. Okay. He has to pay $130,000 by September 20th. I mean, he could probably pay that, right? I think he could pay that. Conclusion. For the above reasons, plaintiff's motions for sanctions for failure to preserve ESI is granted. Default judgment against Giuliani on plaintiff's claims is imposed as a sanction under both Federal Rules of Civil Procedure 37, Section A2C and 37B2A6. Before a final judgment may be entered reflecting the amount of compensatory and punitive damages, if any, to be awarded to plaintiffs, a trial on such damages is required, and the parties will be directed to confirm and propose 3 dates for damages trial by early 2024. Oh, it's going to be a packed year for you, Rudy, Tooty, fresh and fruity. In preparation for a trial on damages, Giuliani and his eponymous businesses will be directed again to produce by September 20th records relevant to the quantifications of damages that they were required but still have failed to produce. First, Giuliani is directed to produce complete responses to plaintiffs' requests for financial documents set out in plaintiffs' RFPs 40 and 41. See that, Supra. Second, Giuliani is directed to ensure the Giuliani businesses produce complete responses to plaintiffs' requests for financial documents and viewership metrics, inclusive of records responsive to these RFPs. See Supra. Third, Giuliani is directed on behalf of his businesses to confer with plaintiffs regarding the designation of one or more corporate representatives on behalf of the Giuliani businesses. Who wants to bet it's Dr. Maria? Well, somebody's pocketbook is open, don't go. So he needs to find whoever's pocketbook is open and dig his hand in there. Finally, Giuliani's failure to comply with the orders will result in a mandatory instruction about his concealment of his net worth, though should he provide by September 20th, 2023, fulsome responses to plaintiffs' RFPs, the mandatory instruction may be converted to permissive. With respect to Giuliani's obligations to reimburse plaintiffs' attorneys' fees and costs, Giuliani's direct. Yeah, it's getting old. To reimburse such fees and costs associated with plaintiff's successful first motion to compel discovery in the amount totaling $89,072.50, with interest on the amount from July 25th, 2023. And, well, to reimburse such attorney's fees and costs associated with plaintiff's motion for sanctions to ensure the Giuliani business. And 3, to ensure the Giuliani business reimburse such costs, fees and costs associated with plaintiff's successful motion to compel discovery from the businesses in the amount totaling $43,684. No sense. Should the Giuliani businesses fail to timely reimburse the plaintiffs this money, he'll bear that cost under a sanction, as a sanction, under this rule and that rule, with interest, to accrue from September 20th. I'm Barrel Hal, and I'm kicking ass, and I'm taking names, bitch! And that's the story of little Rudy Giuliani. Little Rudy Giuliani. Well, I think we did pretty good, actually. I doubted I could do that, but I did it. I want to thank the person who sent me that document this morning and said, you should read this. No, actually, he didn't say. He said, are you going to read this? I said, I don't know. I am now. No, actually, I really wanted it. So I'm glad I got it, because I didn't have access to it. I didn't have it in my hot little hands. In my hot little hands. I did. No, actually, no, you didn't ask. You did not ask. I'm going to make sure the record is correct. Let the record accurately reflect. There was merely the inquiry. It was an inquiry. Oh, Paulina, thank you so much. I just think it's so good to read these, because I really do want to read the source documents, but I will not read them on my own. But if I read them to you guys, I will read them. Does that make sense? That is literally why this is happening, is because I want to read these documents, but I know if I just sit, I will not read them. But if I act, then I will. Well, yeah, hopefully it saves all of us some time. And if you can listen to it while you're, like washing your cat, I mean, bonus Jonas. Yeah, I know you probably do. I mean, basically, you guys do have to reread it, because let's be real about my reading ability. And today I seem to be at an all-time low. And if you give me the word April, apparently I cannot fucking say the word April. It does. It's so much more enjoyable to be with you guys and reading it. Washing your cat. Don't you wash your cat? Oh my goodness. All right. Thank you so much for sharing this amazing day. Congratulations to Ruby Freeman and Shay Moss. And a country owes them a great debt of gratitude for having to endure the death threats and the torture and the incessant harassment at the hands of this fucking piece of trash, this shit bag full of human cells. That's my phone. All of that for these women, I hope they get everything they deserve and more, and that their lives are peaceful and restorative, and that they quickly get the justice that they deserve. So it's too much. And especially Rudy, given everything he's done to people and how abusive he was to Noelle Dunphy and undoubtedly other young women or women in his life and men. I just don't think there's enough. Sometimes I think there's not enough punishment. I don't want to be that way. But at the same time, I just fucking can't. I can't take it. I can't. Yeah. They are. They're the actual patriots. Shay Moss and Ruby Freeman, the mother-daughter team. They shouldn't have been put in this position. They really shouldn't have. And I just hope, I'm really grateful for them for bringing this suit too, because they didn't have to do that. And it put them in more danger and in more, peril. So not only did they endure it, but then they brought the action that would hold people accountable for it. So anyway, on that note, justice is happening. Hopefully everyone in Florida and the Gulf is okay. I was able to check in with friends and they're okay. So I'm happy to hear that, but I'm also concerned about the rising waters and things. So definitely thinking of people in that area and up into Georgia, etc. So be safe, okay? Don't take for granted that water can rise really fast, even inland. So that's what they're noticing, all right? Okay. Summertime and the living is easy. Fish are jumping and the cotton is high. Your daddy's rich and your ma is good looking. And hush, little baby, don't you cry. No, I didn't. Whatever. Does she know who he is? Oh, ouch. I bet she doesn't. Anyway, all right. I will see you later. Thanks again. Have a good one. Hey, bye.